Older Americans, pay close attention. The Supreme Court just handed down a landmark 8-1 decision that fundamentally reshapes the landscape for senior citizens across this nation. Here is the reality no one is explaining to you. Put everything else aside right now because the information I am about to share could return thousands of dollars to your bank account, and the overwhelming majority of American retirees will never even realize this took place. The highest court in the United States just released one of the most impactful rulings affecting older citizens in more than a generation. An 8-1 verdict that validates and broadens the entire structure of the Elder Care Protection Act. Comprehensive bipartisan legislation that had already been moving through the implementation process nationwide. This decision does not merely preserve the legislation, it reinforces it. It eliminates gaps that corporate lobbyists had been banking on. It speeds up deadlines that drug manufacturers were desperate to push back, and it creates constitutional safeguards around senior benefits that no incoming Congress can silently dismantle without triggering an immediate legal confrontation. If you have passed the age of 60, if you are looking after a parent who is getting older, if you are nearing your retirement years, or if you are already depending on Social Security and Medicare, this decision has a direct effect on your finances, your medical care, your housing, and your long-term security, and the consequences are staggering in ways that the majority of people have not yet fully grasped. But here is the part that should leave you outraged. The major news outlets are barely touching the specifics. They handed you the headline, Supreme Court backs elder care legislation 8-1, and then they rushed off to cover the next topic. In the meantime, millions of older Americans across the country have absolutely no clue what is now constitutionally safeguarded, what they are lawfully owed, or, and this is the essential piece, what time-sensitive deadlines they might still miss if they fail to take action quickly. Because here is what the Supreme Court decision did not accomplish. It did not place you automatically into every available program. It did not deliver a payment to your front door. It did not reach out to your health insurance provider. It confirmed and fast-tracked a structure of safeguards and entitlements, but a significant number of those entitlements still demand that you submit an application. Some demand that you refresh your personal records, some operate within specific enrollment periods, and if you let those periods pass, you forfeit access until the following cycle becomes available. So today, we are laying out every single detail. Every significant area this decision addresses in straightforward language. No courtroom terminology, no partisan angle, just the genuine practical financial reality of what has shifted for American retirees and their loved ones because of this groundbreaking Supreme Court decision. Find a pen, write things down, and pass this along to every older person in your life. Let us dive right in. First, let us discuss where this decision originated and why it carries far more weight than an ordinary legislative change. For generations, older citizens in this nation have been quietly battling a system that was never designed with their needs at the forefront. Medication costs that made absolutely no sense. Long-term care homes functioning with essentially no oversight. Social Security raises that drifted further behind the actual expenses of daily living year after year. An avalanche of financial crimes against the elderly that has drained the retirement funds of millions of dedicated American workers, and a judicial framework where whatever safeguards did exist were perpetually under attack by industries with unlimited budgets and battalions of attorneys. These were not minor hassles. These were outright emergencies unfolding silently inside millions of American homes. And for far too long, the courts offered uneven protection while corporate interest groups contested every new safeguard in litigation, hoping to stall, dilute, or destroy benefits that older Americans had struggled mightily to obtain. The 8-1 Supreme Court decision alters that dynamic forever. When the Supreme Court rules with this degree of unanimity, it does not simply resolve a single dispute. It establishes constitutional authority that influences every subordinate court ruling, every regulatory measure, and every legislative effort to alter these safeguards moving forward. The sole dissenting justice wrote on narrow procedural technicalities, not on the core substance of protections for the elderly. The 8-justice majority opinion was expansive, precise, and unmistakably clear in its defense of older Americans. This decision stands as one of the most pivotal legal milestones for senior citizens in contemporary American history. And the reason this demands a thorough discussion is because headlines come and go quickly. But the specifics, the actual tangible reforms, are where the genuine financial relief and genuine security reside for you and your loved ones. Let us begin with the reform that is already sending shockwaves through the pharmaceutical industry: prescription medication pricing overhaul. If you are enrolled in Medicare, this is the news you have been anticipating throughout your entire retirement. For years, Medicare, the single largest buyer of prescription medications in the entire United States, was legally forbidden from bargaining over drug costs directly with pharmaceutical manufacturers. Let that sink in again. The most massive purchaser of medicines in the country was prohibited by statute from leveraging its enormous buying power to drive prices lower. Private health insurers could bargain. The Veterans Affairs Department could bargain. But Medicare, which currently serves more than 67 million Americans, was not allowed to. The outcome was that elderly Americans in this country were shouldering some of the steepest medication prices anywhere on the planet for the identical drugs that citizens in Canada, Germany, and Japan were obtaining at a small fraction of the expense. Medication pricing reform addressed that injustice. And what the Supreme Court's 8-1 verdict just accomplished was shutting down every outstanding legal effort that drug companies had launched trying to destroy the negotiation framework before it could become fully operational. There were 11 distinct active lawsuits against Medicare drug price bargaining proceeding through the federal court system. With this Supreme Court verdict, those lawsuits are essentially finished, not postponed, not returned for further review. Finished. In real-world terms, if you are presently spending $200, $300, or even $500 every month on treatments for diabetes, cardiovascular disease, joint conditions, hypertension, or high cholesterol, there is a genuine possibility those expenses are going to decline, not at some vague point in the future, on a phased timeline that is now constitutionally secured and legally expedited. The verdict also confirms the yearly maximum out-of-pocket medication expense limit for Medicare recipients. That means there is now a constitutionally anchored legal limit on the total amount you will ever need to spend in a single year on prescriptions, regardless of how many medications you pick up, regardless of how costly those drugs happen to be. For the millions of elderly Americans who have been compelled to decide between picking up a prescription and putting food on the table, this is not a minor adjustment. This is transformative. What should you do right now? Reach out to your Medicare Part D provider and verify your maximum out-of-pocket threshold for 2026. If you have been putting off filling a prescription because of the expense, phone your plan representative and inquire how the newly negotiated pricing adjustments apply to your particular medications. You could be overpaying at this very moment without being aware of it. Now, let us discuss Social Security, because this is the portion that gets people emotional, and for very good reason. Social Security has served as the economic foundation of American retirement since 1935. It was created as a solemn covenant. You labor, you pay in, and when your career concludes, the system provides for you. But gradually, that covenant began feeling uncertain. Cost of living increases, referred to as COLA, are intended to shield your benefits from rising prices. Each year, the Social Security Administration reviews inflation figures and recalculates your monthly payment. But here is the uncomfortable truth that older Americans have been raising their voices about for years. The inflation calculation they rely on does not mirror the way seniors actually spend their money. The standard calculation monitors the purchasing behavior of city-dwelling workers, fuel costs, technology, professional expenses, but seniors spend in different ways. You allocate more toward medical treatment, prescriptions, personal care assistance, and household utilities, categories where prices climb faster than nearly everything else in the marketplace. The consequence has been that older Americans were technically receiving inflation increases, but losing actual buying capacity with every passing year. The Elder Care Protection Act advocated for implementation of an inflation measurement specifically crafted to monitor senior spending behaviors. The drug and insurance sectors challenged this requirement in the courts, contending it went beyond what Congress was authorized to mandate. The Supreme Court, in its 8-1 judgment, determined that it does not. The senior-focused inflation measurement is constitutionally valid and must be put into practice by law. In plain terms, your yearly Social Security increase will at last begin tracking what your daily existence genuinely costs. Over the long haul, this could translate to hundreds of additional dollars annually in your pocket. When you are surviving on a set income, a more precise inflation calculation compounding year over year builds into something extraordinary. We are talking about thousands of dollars across a decade in supplemental payments that you would never have received under the previous calculation. The verdict additionally confirms the measures that fortify Social Security's sustained viability by recalibrating the payroll tax threshold so wealthier earners pay their fair share, reinforcing the program for everyone alive today, for your sons and daughters, and for their children. What should you do right now? Sign into your My Social Security portal at ssa.gov and confirm your benefits summary shows the latest COLA modifications. If you suspect there is an error, reach out to the Social Security Administration directly to initiate a formal review. Now, let us shift to nursing home reform because this element of the verdict receives far too little coverage and it is absolutely vital. The painful truth is that nursing facility mistreatment and neglect across America has been an ongoing, heartbreaking crisis. Government investigations have consistently revealed that an alarming proportion of nursing facilities have been flagged for critical infractions. Understaffing, unsanitary conditions, prescription errors, and in the most extreme situations, deliberate physical and psychological mistreatment. The nursing facility industry pushed back against updated staffing mandates and penalty frameworks through numerous court filings. They claimed the minimum staff-to-patient ratio mandates were an administrative overreach and an unreasonable economic hardship. The Supreme Court, in its 8-1 verdict, sided overwhelmingly with the protections for older Americans. Under the now constitutionally validated requirements, nursing facilities that accept Medicare or Medicaid reimbursement, which represents virtually all of them, must meet significantly tighter staffing standards. The updated regulations establish mandatory minimum staff-to-patient ratios that now carry the full weight of law. Your mother or your father will have a qualified, trained professional present when assistance is needed, not a lone, exhausted aide struggling to cover an entire wing by themselves. Consequences for safety infractions are being substantially increased. Previously, monetary penalties were so minimal that countless facilities absorbed them as routine operational costs. That practice ends now. Fines are escalating, and habitual violators risk having their Medicare and Medicaid funding revoked completely. For the vast majority of care homes, that amounts to a financial catastrophe. There are also disclosure mandates that are now completely operative following the Supreme Court ruling. Nursing facilities are obligated to make their inspection findings, personnel records, and infraction histories publicly and readily available. That means when you investigate a care home for yourself or someone you love, you will encounter the unvarnished truth, not merely the polished pamphlet they present at the reception area. What should you do right now? If you have a relative currently residing in a nursing facility or assisted living center, visit the official Medicare Care Home Comparison resource at medicare.gov to review their most recent inspection findings and staffing statistics. If you harbor concerns about the facility providing care to your loved one, you now possess more robust legal standing than at any previous point to insist on accountability. Now, let us turn to something that fails to receive the recognition it warrants. Financial exploitation of the elderly. This is a quiet catastrophe draining American seniors of tens of billions of dollars each and every year. The fraud schemes are everywhere. Bogus IRS telephone calls, Medicare swindles, investment cons, romantic manipulation targeting isolated widows and widowers, home repair workers who collect a down payment and vanish, and heartbreakingly even relatives or caretakers abusing their proximity to an elderly person's finances. The trade organizations speaking for banking institutions had contested particular mandatory disclosure requirements embedded in the fraud prevention sections, claiming they created excessive regulatory obligations. The Supreme Court dismissed that position entirely. 8 justices concurred that the government's compelling interest in shielding older Americans from financial predation justifies the notification and coordination mandates. That means banks and credit unions are now compelled by law to identify suspicious activity on senior accounts and maintain defined procedures for reporting possible exploitation. A sudden substantial withdrawal, multiple electronic transfers to unknown accounts, an unfamiliar name abruptly appearing on an elderly customer's account. These are warning indicators, and financial institutions now possess both the legal obligation and the liability coverage to intervene. The verdict also confirms allocated federal resources for elderly fraud prevention and criminal prosecution. That means additional federal agents with specialized training to investigate these offenses, expanded resources for helping victims recover losses, and enhanced cooperation between federal departments, state police forces, and banking organizations. There is also substantial investment in public awareness initiatives directed at seniors, because the most effective shield against fraud is information. When you recognize the strategies that con artists employ, you become virtually impossible to deceive. What should you do right now? Get in touch with your bank or credit union and inquire what senior financial safeguard measures they now have operational. Activate account notifications so you receive alerts for any major transaction, and record the official telephone number for the National Elder Fraud Helpline, which is 1-833-FRAUD-11, and store it somewhere you can easily reach it. Let us discuss housing and remaining in your own home. For the majority of seniors, your residence is your most valuable possession and the center of your world. The capacity to age in your own home, to grow older, enveloped by your memories in your own neighborhood, is something virtually everyone desires. But our residences were not constructed for the later chapters of life. Staircases become hazardous. Bathrooms lacking safety rails become zones for serious injury. Cramped door frames become obstacles to self-sufficiency, and renovations can run into thousands of dollars that seniors on limited incomes simply cannot spare. Housing adaptation assistance programs were contested in litigation over their funding structures. The Supreme Court validated the complete financing and rollout framework, meaning older Americans throughout the nation can now utilize these programs without the doubt that had been looming over them. Qualifying seniors can obtain financial support to construct ramps, expand doorways, install accessible showers, enhance lighting, and adapt kitchens for easier use. These are not extravagant remodels. These are the upgrades that allow you to remain secure, self-reliant, and outside of an institutional care setting. When you weigh what professional care facility expenses amount to, enabling seniors to remain safely in their own homes through reasonable adaptations is not only kind-hearted, it is financially sensible. The verdict also confirms substantial investment in reasonably priced senior housing communities. Residences built with accessibility, medical service proximity, and meaningful social engagement as guiding principles. Why is this so profoundly important? Because persistent isolation among older adults has been demonstrated to be as harmful to physical health as consuming 15 cigarettes daily. That is not hyperbole. That is verified scientific evidence from leading health research organizations. The social framework of senior living environments carries equal significance to the structural features themselves. What should you do right now? Reach out to your regional area agency on aging, which you can locate through eldercare.acl.gov, to inquire about housing modification support programs accessible in your particular region. These organizations can link you with both federally backed programs and state-administered resources that could be open to you. Now, let us confront something that has been persistently under-resourced and insufficiently recognized: mental health services for older Americans. The Supreme Court verdict upholds significant provisions widening access to psychological wellness services for seniors enrolled in Medicare. At present, obtaining mental health treatment through Medicare is convoluted, costly, and restricted. Numerous therapists and mental health professionals refuse Medicare patients because payment rates have traditionally been too meager to sustain their practices financially. The legal objections to enhanced mental health payment structures originated primarily from managed care companies that insisted the updated reimbursement levels would inflate plan expenses. The Supreme Court found those objections inadequate. The mental health expansion requirements are confirmed in their entirety. That means elderly people in remote communities, seniors with physical limitations, seniors who have been quietly enduring grief, worry, sadness, or the dread of losing their autonomy now have pathways to virtual mental health treatment that were not practically reachable before. Mourning, personal loss, ongoing physical pain, anxiety about becoming dependent. These are genuine weights that millions of aging Americans shoulder each and every day without speaking a word. Assistance is now becoming available in ways that have never existed previously. What should you do right now? Consult your Medicare provider about mental health telehealth benefit options. You may qualify for counseling programs that your insurance company is not voluntarily bringing to your attention. Let us address caregiver assistance because this touches tens of millions of American households and almost never receives the spotlight it merits. There are roughly 53 million unpaid family caregivers across the United States at this moment. Sons, daughters, husbands, wives, brothers, sisters, individuals who have shouldered the tremendous obligation of looking after an aging family member while simultaneously holding down employment, bringing up children, and tending to their own well-being. The emotional and physical cost is immense. Caregiver exhaustion is a documented reality. Clinical depression among caregivers is remarkably prevalent, and throughout history, these unsung champions received practically no monetary assistance, no substantive education, and no societal acknowledgement. The caregiver tax relief provisions within the Elder Care Protection Act had been contested on tax law procedural grounds. The Supreme Court validated those provisions. Family members providing care can now access meaningful tax relief for verified caregiving expenditures. There is also dedicated funding for caregiver education initiatives and broadened respite care alternatives so those providing daily care can step away temporarily without experiencing guilt or economic hardship. A supported and properly educated caregiver delivers superior care. When those who give care reach their breaking point, elderly loved ones bear the consequences. When caregivers have a foundation of support, the whole household thrives. This is a transformation that extends into millions of residences across the nation in ways that the news summaries simply cannot convey. What should you do right now? If you are providing care for a family member, speak with a qualified tax advisor about the caregiver tax relief provisions that are now applicable to your circumstances. Maintain records and documentation for every care-associated cost because the record-keeping standards for utilizing these credits are detailed and you want to have everything in order. Now, let us examine the Medicare expansion category that has fueled passionate disagreement for years: dental care, eye care, and hearing services. Traditional Medicare does not include routine dental treatment, vision examinations, or hearing devices. This exclusion has always been conspicuous because untreated oral disease is directly connected to cardiac illness and cognitive decline. Vision impairment causes falls, which rank among the primary causes of fatality in elderly adults, and hearing deterioration is one of the most significant predictors of mental decline. These are not cosmetic luxuries. They are essential healthcare necessities that have been left out of Medicare coverage in ways that defy both clinical reasoning and fiscal logic. The dental, vision, and hearing requirements contained in the Elder Care Protection Act encountered legal opposition from medical provider associations and insurance industry spokespersons, contending that rollout schedules were impractical. The Supreme Court dismissed those contentions. The rollout structure is validated and the expedited schedule carries binding legal authority. New financial assistance will enable Medicare recipients to afford hearing devices, which commonly run between $3,000 and $7,000 in personal expenses. Trial initiatives broadening dental care availability through federally certified community health clinics are now proceeding with complete legal backing, and investment in vision care through neighborhood health programs is growing. This does not encompass everything that consumer advocates had pushed for, but it constitutes a constitutionally affirmed major advancement in the proper direction.